Hi everyone, this is U.S. Immigration Attorney Sharifa Tharpe, and I am here live to take your U.S. immigration related questions tonight. So if you have a U.S. immigration related question, go ahead and put your questions in the comments right now so that I may answer your questions. I always like to close the night out with you, and here I am to do exactly that, to take your immigration related questions, and it can be anything that is immigration related. You can go ahead, put your questions in the comments at any time. So starting even now, while your questions come in, I'm going to formally introduce myself. For those of you who don't know me, I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their green card and status in the United States. I also come on every day with very few exceptions to talk with you, to answer your questions, to give you very good, valuable information. And so tonight is just another night for me to do that. So what you can do is go ahead, put your questions in the comments. If you want to learn more about me, you can go to the link in my bio. You'll see that one of the options is to go to the website. There is a scheduling coordinator who is available up until 11 p.m. if you want to skip a question here and just go ahead and ask your questions. So go ahead, put your questions in the comments. So with the ICE camps, are they actually helping immigrants or just planning to send them back? So, this is definitely something that I don't support. And, while they're going through, there is an immigration process. And so they keep them in these camps because they don't. And right now, I believe that some of them they're trying to reduce that. They're trying to clear them out. They're trying to release individuals and reverse some of the Trump administration's policies. However, there is a process, and a part of that process is going through immigration court to determine whether if they're seeking relief, if they can stay, or whether they must go. And so that is the main reason for detention, even though I don't support it and I don't think it's very just. It's very just for a majority of cases. That is one of the main reasons that they have them, is to hold them and let them go through the process when they're detained, is to go through an immigration process first. What if you have a misdemeanor on record that was dismissed? Does it stop you from getting I believe that's an immigrant visa? So it could possibly. It's Prince 21. That's where it's very, very important for you to get legal advice. Because when you have a misdemeanor under immigration law, they could still see it as a very severe immigration violation. So very important that you get legal advice. I cannot stress this enough. Because when it comes on to criminal issues, it's really on a case-by-case basis. And it really depends on the facts of your case. So keep that in mind. You can always schedule a consultation by going to the link in my bio or calling 561-405-4889 to schedule a consultation. Can owing the state taxes prevent me from getting my citizenship? I have been a PR for 10 years. So now, I don't want to advise on any tax issues. I don't know what your circumstances are. And so it's very important for you to get legal advice. Now, owing taxes can definitely impact it could definitely impact your citizenship. However, they usually look at federal income taxes. But you must get legal advice because this can go into more complex territory. So you want to make sure SAM that you get legal advice. During yours, do not sit on this. Make sure you get legal advice. You can call, schedule a consultation, and we can take a look at your circumstances. For example, now if you owe the taxes and you're paying the state taxes, then that may not necessarily be a problem. Now, owing taxes and making sure you're paying them, whether it's federal or state, is not going to reflect badly on you. Where it's going to reflect badly on you is where you owe it and you're not paying it, so it's delinquent. So you want to make sure that you are on top of that, and then schedule a consultation, and we'll get more in detail with your tax issues. But when it comes down to that, I cannot give you personal legal advice about your state taxes. I need to know what the circumstances are, what kind of taxes are they. You owe state taxes, but are they in some way related to the federal taxes? So very important that you contact us, schedule a consultation, call 561-405-4889. Can an uncle sponsor his nephew? Unfortunately not. An uncle can sponsor their sibling and then bring the children along who are under 21 and unmarried. But otherwise, there's no direct sponsorship between an uncle and a nephew. Can someone get back a revoked visa if no reason given for the revocation? It may be possible. However, keep in mind that usually there is a reason behind the revocation, even if you didn't find out what it was. They may have gotten a tip that you worked, or they may have gotten a tip that you were planning to overstay, or they may have gotten a tip that you had immigrant intent. So and it may be even more serious. Maybe there are more serious issues involved. So where it is possible, you could be facing an uphill battle because you don't know what the reason is. They have a reason, you just don't know what it is, and you probably will need to find out what that is in order to fix the situation. Can I still apply for the E2 if I had a canceled visa? So now it depends. That's where it's important to get legal advice, because if your visa was canceled, why was it canceled? Usually it's canceled where there is some sort of violation or suspicion of a violation. So it's very important for you to get legal advice about what this cancellation was about, because canceled visa could mean misrepresentation. It could mean that they thought you were going to overstay. But keep in mind, the E2 is also a non-immigrant visa, and so if it was canceled because they think you have immigrant intent, then they may not approve the E2, because with the E2 you're not supposed to have immigrant intent as well. Immigrant intent means that you're going to stay in the United States. Can an uncle sponsor his nephew and family, and how long will it take? So no, an uncle can't sponsor their nephew. Only state taxes, not federal, but I will call. Thank you so much. You're welcome. SAM427, go ahead, call. Let's talk more about your situation. Work with, let me see, can an uncle give a nephew a work permit? No. So work permits are usually related to an application that allows for a work permit. For example, an adjustment of status process. If you're talking about an employment-based visa, a relative can sponsor another relative as their employer. But keep in mind that you still have to meet certain requirements. Your relative still has to show that that they do require you as an employee, that you qualify, and also go through what's called a labor certification process. So keep those questions coming, and these are all great questions so far. Akeelia Honeybee Johnson, thanks for sharing the live. Geeta Singh, good night. It's always nice to see you. So keep those questions coming. So far, all your questions have been great, and I am here to answer exactly these type of questions. So go ahead and continue to put them in the comments. As long as I'm here, I am going to answer them. Now, so apology through text messages count as proof of physical assault. So Varun, any credible evidence can work. So any credible evidence. And so in this case, text messages can also count as evidence of assault or abuse. So while I cannot give you personal legal advice, it's very much possible that the text messages could serve as good evidence, especially when they're time stamped and it clearly shows the text message conversation between the two parties. Silverwild, thanks for sharing the live. I appreciate that. So since Varun brought this up, I'm going to talk about this again. And this is applying, I'm going to talk about this in two contexts. If I have time, I'll cover all two of them. But this is first, if you're here without your papers, or you're even here, but you're here as a non-immigrant, and you want to apply for permanent residence, can you apply without an abusive spouse, an abusive or another type of abusive relative? And the answer is yes. So now I'm going to, you can apply for permanent residence on your own and apply for a work permit and stay in the United States, even if you came into the country without your papers, even if you came into the country with your papers but you overstayed. So this is what you need. You first need to qualify based on mistreatment or extreme cruelty by a U.S. citizen or a legal permanent resident spouse, if you're under 25, a parent, or a citizen son or daughter who's 21 and up. Now, once, this type of mistreatment does not necessarily mean that you are, it has to be physical, that you had to call the police, that you had to be in the hospital. It could involve, it could involve the physical abuse. It could involve verbal abuse. Doesn't have to involve physical. Verbal abuse, emotional abuse, even financial abuse. So if your visa application is placed into administrative processing, what does it mean? So it's kind of like a black hole. And it could mean that your case is under review for some reason, and it could be there pending for a while. So yes, apologizing, mentioning for hitting someone. So that could very well be credible evidence. So keep in mind that to show evidence of mistreatment doesn't necessarily have to involve a police report or pictures or a video showing a physical assault. It could involve text messages, emails, other types of messages, WhatsApp messages. It could involve even your detailed statement. It's called a declaration. And if it's credible, if the officer finds it to be credible, they will accept it as evidence. So how long does asylum people go for their interview for the green card? So it's very backlogged, and unfortunately it is taking years right now. What you can do is, if you go to uscis.gov and you go to case processing times, you'll be able to see the service center that's processing your case, and you can see, look by form, and you'll be able to see what range of time they're taking to process asylum cases. So continue to put your questions. These have all been great questions so far, and I'm here to answer your questions. I'm also talking about applying for the green card on your own. So applying for permanent residence on your own in the case that you're being mistreated by certain qualifying relatives. So I went through that list, and the list of qualifying relatives, it has to be a U.S. citizen or legal permanent resident spouse, or if you're under 25, a parent, or a citizen son or daughter who is 21 and up. They could be verbally mistreating you. They could be mentally. They could even be financially, emotionally. These do count. Abuse is abuse, and it doesn't have to be physical. So Varun, yes, lot of verbal abuse. So absolutely that counts. So if your spouse is controlling, if they are calling you names, if they yell at you constantly, if you find that they're gaslighting you, if they're subjecting you to extreme cruelty, and extreme cruelty comes in different forms, then this is something that you could apply for, and it's a form of relief that is here for you. And you, even if you're undocumented, even if you're without status, even if you overstayed, even if you came into the country without your papers, you can still apply for this on your own and get a work permit while you wait until it's time for your green card interview. I was going to visit my girlfriend in America and I was turned back at the airport. My visa was revoked. So Kingpin 92, I'm so sorry that happened to you. And you know, at the time that you're coming in on your visa, it could be a number of reasons. So for example, if they ask questions and you didn't answer the question in a way that they thought was truthful, that could definitely lead to a revocation. If they suspected that you were going to come and not go back, that could definitely lead to a revocation. There is some reason. Usually when they turn you back, they give you a document, and it usually has a sworn statement that it basically lays out why they turned you back. Now, the 5 years, so once they turn you back at the border, you are barred for 5 years, and they call this expedited removal. And you would not be able to come back before the 5 years unless you apply for a waiver if you are inadmissible for some other underlying reason. So for example, if they found misrepresentation, then that's a lifetime bar. You'd have to apply for a waiver, and in addition to that, apply for permission to reapply for re-entry. So there are two types of applications that you'd have to apply for. So Kingpin 92, in the case that you do want to return, it's very important for you to get legal advice because it does get a lot more complex. So you want to make sure. The number one issues here is, why was it revoked? What is the immigration charge, if there is? And also how to overcome that 5-year bar. You can call 561-405-4889, schedule a consultation, and we can talk. There is a scheduling coordinator who is available up until 11 p.m. tonight. And from now until, so Monday to Friday. SAM 427, my husband was abusive. I divorced him in 2017. So SAM 427, now if your husband was a green card holder or he was a U.S. citizen, and he and you divorced him for less than 2 years, this could possibly be a path. Now, this is also a good way to get relief if you've already obtained a divorce and you still need status. If you have been divorced for less than 2 years from an abusive spouse, U.S. citizen or legal permanent resident spouse, this is also a way. Razor Kill, you're doing a good job. Thanks again. God bless. Thank you so much, and same to you. I've been a permanent resident since 2010. This should not affect me getting my citizenship. So now if you have now SAM 427, I don't know what your situation is. I don't know what history you have. How did you obtain your permanent residence? However, generally speaking, once you've had your green card for over five years or more, you're not applying based on a marriage. You're applying based on your the other qualifications, that you have good moral character, that you you've had your permanent residence for the amount of time that you're required to have it for, that you've had continuous residence in the United States and physical presence in the United States. These would be the most important qualifications here for you. So my son is coming as an international student. Can I apply for I-130 after he comes? So Ramsey, it could be possible, but it depends on what is your status. Are you a U.S. citizen? What is the age of your son? How long will he have the student visa for? Because if he's going to have the student visa for a shorter time than the process will take, then you could run into a complicated situation. So this is where you definitely have to get legal advice to make sure that you really evaluate your options and that you can plan ahead. So Ramsey, thank you so much. I'm glad I'm helpful. But this is going to be a complex question that's going to involve a more detailed evaluation of timing. Timing is going to be everything here. Status, what is your status? What is your son's age? And how long will your child have their student visa for? So very important to understand these things. How long does it take for F2B category? So the F2B, I believe that right now is taking 5 to 6 years. So if we're talking about the F2B is the son or daughter 21 and up of a green card holder, and that is taking 5 to 6 years. How do I go about applying for a visa? So you'll have to apply at the embassy. And the main thing, if we're talking about a visitor's visa, is you have to show strong ties to your home country. So that means, when I say that, I mean you have to show such strong commitments to your country that you will, exactly, Sharon, and I must stress, unmarried. So your son or daughter, 21 and up, who are unmarried, is taking 5 to 6 years. So, you must show strong commitments to your country that will convince the officer that you will return after a temporary visit to the United States. So for example, a long-standing job, a business that you have, if you have strong family ties, if you have another commitment like school, that you're in the middle of a program that you can't leave, these could be good evidence of strong ties. So keep putting those questions in the comments, because I'm here to answer your U.S. immigration related questions. So go ahead and put those questions in the comments right now so that I may answer your questions. I'm also talking about how to apply for permanent residence on your own in the case that you're being mistreated by certain qualifying relatives. So is it better to use an agency or not? So Chef Campbell, I wouldn't be able to answer that, because the agencies that you probably are talking about would be in your country, and I don't know what those agencies what they do. I know here in the United States it's not recommended, especially when these are not attorneys. They don't understand the legal issues that may be involved, and they might very well cause more damage in your case. So you want to make sure that you're very careful with how you're choosing the person who will complete your visa application. If my husband is a permanent resident, do I have to go back home for my interview? So Sharon 2921. If you're out of status in the United States and your husband is a permanent resident, there is a waiver process, but you can wait in the United States for the waiver to be decided. If it's an approval, then you can leave for the interview in your home country. So yes, at some point in the process, you will definitely have to leave. What if you owe the IRS about $6,000 debt? Will that stop you for applying for a spouse visa for my spouse? So where you want to make sure that you comply with the IRS, make payments, file your taxes as usual. Now, where it could definitely have an effect is with the affidavit of support, where they do require justification for why you haven't filed taxes. If you have filed taxes, then you also may have to show that you have paid those taxes. So very important that you get legal advice about your situation to determine how you can approach it. So Chef Campbell, so from experience, what are the chances of a visa being approved after administrative processing? So it depends. It depends on what the situation is. So Roxy Sauce 2, thanks for sharing the live. If someone was turned back and your son is a U.S. citizen, can he file for you within the 5 years? So CRAW 938, that is a possibility, but keep in mind that it depends on what happened. What happened to make them get turned back? Is there an underlying immigration violation? And what is the immigration consequences? Can that be overcome? There are ways to apply for permission to reapply for re-entry, but what else is there that would maybe require a waiver? So very important. And do they qualify for a waiver? So very important for you to get legal advice. Okay, so Sharon, so you're not in status. So if you're not in status, you will not qualify to adjust status in the United States, and you have to go through the waiver process as long as your spouse continues to be a permanent resident. So, and also Prish Mond, so get legal advice. Keep in mind that they do require your tax returns in the affidavit of support process, but there are also ways to get a co-sponsor. So there are different options, but it just depends on what the facts are in your situation. And so get legal advice. It doesn't necessarily have to stop you, because I have had clients who owe tax debt. However, did you file taxes? Are you delinquent on your taxes? These would be the questions that I would have to ask to get to the root of the issue here. So Sharon 2921. So I am in status. Okay, so you are in status. So you didn't overstay your visa. So Sharon 2921. If you're here on a visitor's visa and your spouse applies for you, you still would not be able to go through the process, because what will happen is that you're only allowed to stay here on a visitor's visa for so long. But keep in mind that applying through a permanent resident spouse takes about 18 months to 2 years right now. And so at some point in the process, you could fall out of status if you have a visitor's visa. If you have a longer term visa, so an employment-based visa, that's going to last 2 years. So at least 2 years where you can maintain status for the duration of the time that you're applying, then adjustment of status, you could definitely, that is a possibility. Now keep in mind that the information here I'm giving you is general information and it's not personal legal advice, but it's a good start. The information I'm giving you can really guide you as to where you need to go, whether you need further legal advice or whether you can get some reassurance from the general information. Very important you get legal advice in this kind of situation though, because there is a more complex process. If your spouse continues to be a permanent resident, you're going to have to definitely go through that process. How do I go about getting an employment visa? So Chef Campbell, an employer would have to sponsor you. Does Custom have the right to search your phone? So there really are, at the border, there really are not necessarily any rights at the border. And so that is a possibility that they could definitely search your phone. And if you don't, then, of course, you could face further consequences, and which would be hard. It's harder to enforce your rights at the border, just because at that moment you don't have an attorney present, and you have very little right. And so it's very important for you to understand, though, that yes, your rights are limited at the border. So keep those questions coming, because I'm here to answer your U.S. immigration questions. So put those questions in the comments right now so that I may answer those questions. Hi there, Queen just said. It's nice to see you, and thanks so much for the compliment. Now, I have been talking about applying for permanent residence, mistreating you verbally. If they're mistreating you verbally, emotionally, physically, mentally, then this could definitely be a way for you to apply for permanent residence, obtain a work permit at the same time, while you wait for the process to go through. And this is the case even if you've fallen out of status. How to go about getting an F1 visa. So in this case, there are such a number of different employment-based visas. So it's very important that you get legal advice. It really depends on the employer, your qualifications. So very important that you get legal advice because it's going to vary depending on the type of visa and also on the employer and the needs of the country. So keep your questions coming because I'm here to answer your U.S. immigration related questions. Now, I am here every day. So even when I leave today, keep in mind that I will be back tomorrow. So follow me, and as soon as you see me go live, you can hop on and ask your questions. Is there any immigration policy coming up to handle the visa backlogs? So internally, I know that they are trying to work on fixing that. However, nothing has been outright announced, but they are trying to work to fix it. And keep in mind, there are hundreds and thousands of applications in the backlog, so it is going to take a little while to fix that. Is the process the same for students with F1 status as you explained for Sharon 2921? So no, I think you're talking about applying through a permanent resident. And yes, so if you, as long as you maintain your legal status for the duration of the process, then adjustment of status could be a possibility. But Lennox, this is where it's very important to get legal advice because, you know, how long will you have your student visa for? Who is applying for you? How do you qualify? So my friend's wife disappeared with his child immediately after marriage. What are his options? So this would seem more like a family immigration, a family issue. And what your friend will need to do is consult a family attorney to see if there are ways to, you know, seek the wife out and then obtain custody. So that's not an immigration issue. It's going to be on the family law side. Can I apply for my Vowel case before my divorce? And do I have to get a lot of proof? Great question, user 17606. You can apply for the VAWA at any time during your marriage and also up to 2 years after your divorce. So you don't have to wait until your divorce. Now, I don't know if you're undocumented or if you are referring to the 2-year permanent residence and getting the 10-year. When you're getting the 2-year, when you have a 2-year permanent residence and you're applying for the 10-year based on mistreatment, and you do need to show that you have been divorced along with evidence that you have a bona fide marriage to be able to get the waiver. Now, when it comes on to proof, I can't speak to whether, you know, a lot of proof. It's really on a case-by-case basis. Sometimes it just takes one document. You know, it could be a document that's showing compelling evidence of abuse or mistreatment, or it could be little pieces of evidence. So it really is on a case-by-case basis. But if your evidence is credible, then it is definitely evidence that can be used in your application. Co-sponsors have to be only family members, so no, it can also be friends. She was supposed to be assisting in his status adjustment of status. So that is where definitely he should get legal advice because that can definitely fall under a VAWA situation. So if she was using the child, for example, as a crutch, as a way to control him, if she was mistreating him at the same time, then this is definitely a basis of extreme cruelty and abuse. So he should definitely schedule a consultation. There may be a way for him to adjust status on his own through the VAWA process. He can call, schedule a consultation. You can share his information and share my information with him, and then he can decide whether he wants to get in touch with me and schedule a consultation. I didn't go for my interview. My wife didn't want to go with me. So user 17606. These are the exact cases that I'm talking about. Now, this is the case, right? When you have a spouse that's mistreating you, they also do things to sabotage your green card process or permanent residence process. And this is one of the tactics. They don't want to show up for the interview, or they hold it over your head to get you to do what they want. And so this is where you evaluate your options to determine whether you can move forward on your own through a separate process based on mistreatment. If there's a pattern of mistreatment against you by a U.S. citizen or legal permanent resident spouse or parent or child 21 and up, then this could be a way for you to finish out your process and get what you deserve despite what you have had to go through. I was blanked for a visa twice. It is possible because my husband was deported 20 years ago. So Casey, that could be possible. I don't know what the facts are in your case, but that is a possibility. For example, if your spouse was deported because of drug trafficking, for example, or smuggling, if you are the spouse of that person, it could affect your admissibility as well. So very important that you pay attention to the reason he was deported and see if somehow it could be affecting you. My case is still pending. So user 17606, if you really feel like you're running out of options, schedule a consultation, see what your options are. Because even if it's still pending, you could possibly fix your case by applying for this petition on your own. So Natasha, I have an approved I-360, and see, this is great. This is exactly what I'm talking about. And Natasha has seen the other side of that. So Natasha has applied for the I-360, which is what you call this type of petition, where you can apply on your own based on the mistreatment. How long is it taking for a K1 visa? Like the appointments, I heard 2 to 3 years. Is that true? So no, not necessarily 2 to 3 years. Maybe in some freakish situations, but it's taking up to 18 months is around the average time, 12 to 18 months. A person was permitted 1 month and they sent 22 days. Is that considered an overstay? So a person was permitted 1 month and they sent 22 days. Is that considered an overstay? I'm not. No, if they were given 1 month and they stayed for 22 days would be under 1 month, and that doesn't necessarily clearly show an overstay. Now, if they stayed 22 days over the time that was permitted, that could be a problem. And it could be a problem. Now, while it wouldn't necessarily result in a permanent bar, if an officer sees, they could see this negatively and they could possibly revoke, cancel the visa, or not renew it the next time you go and apply. So as requested to submit a medical, how long does USCIS take to make a decision? And what does that? So it depends on if you're doing the medical, and they sent it to you through an RFE, it could take a couple of months. It's hard to give you any, information about a timeline. I'm not the attorney on your case, and so I don't know where you are in the process. Did you attend the final interview, and is that where they gave you the request for the medical? So it could take weeks to a couple months if this was done through a request for evidence. W Davy 40, thanks for following. Small Town Girl 13, you're welcome. How long does it take for an approval for a Prima Facie? So right now I'm seeing about 3 months. All right, thank you so much everyone for tuning in, and thanks so much for your questions. Today I talked about applying for permanent residence on your own through the Vowel process, and I got amazing questions at the same time. Keep in mind that this is not the only time I'll be live. I'm here every day with very few exceptions. So if you have a question, you can save it for next time. Also follow me so that you can see when I go live, you can hop on with me. If you want to learn, Sexy Annie 35, always nice to see you, and you are welcome. If you would like to learn more about me as a U.S. immigration attorney, you want to schedule a consultation, go ahead, go to the link in my bio. Thank you so much, Sharon. Same to you. M3 Ikab, thank you. You're welcome. Thank you so much. Now go to the link in my bio. It'll take you to the website where you can fill out a contact form if that's more convenient for you. Call. There is a scheduling coordinator who is up until 11 p.m. tonight. Claudia, thank you so much. Thank you. And I appreciate you tuning in and taking in the information I have to give. So thank you for that. So call. There's a scheduling coordinators available. They're available 9:30 a.m. to 11 p.m. Monday to Friday. I urge you to go ahead and schedule your own personal legal advice, because the information I'm giving you today is general information, and it's so important to get personal legal advice to avoid mistakes, to know what you qualify for, to have a game plan, to know how approach your situation, and to have me as your attorney should you decide that you need the assistance. So my 3 jewels, you're welcome, and I hope to see you all tomorrow. Thanks again. Have a good night.